Good afternoon, everyone. I'm your host, Brian Buckmeyer, here in the Law&Crime Trial Network. Previews and recaps, that's the name of the game today. So I'm joined here via Skype with Andrew Cherkasky. Andrew, how are you doing today?
Very good. How are you?
Great, thank you. So Andrew, I don't think that in terms of whether or not he's going to jail, that being Jimmy Rodgers, anyone's going to disagree. I think the evidence came out. We saw how the defense went about their defense. But what's confusing to me is this mixed bag of guilty on some, not guilty on others. What was your view on the verdict?
Well, I've got to tell you, I am confused on that as well. A lot of stuff goes on in jury deliberation rooms. There's a lot of wheeling and dealing, and there's trying to find some middle ground. Here, what we see is the accomplice, the other individual, took a deal for second-degree murder. And now we know the defendant here was found guilty of second-degree murder. I wonder if there's some sort of deal essentially that was made in the jury deliberation room that had him be found guilty at the same level as the other individual, because they felt the other individual was perhaps even more culpable or more responsible, so to speak, had more blood on his hands, literally, than the defendant here. And so that's how they arrived at that decision. I'm not sure that it's consistent necessarily with the facts or the law of the case, but I don't want to do too much guessing about exactly what the jury was thinking. That's just my outside perspective.
Yeah. So Andrew, I'm kind of, and please tell me if I'm wrong here, I'm kind of hearing two great avenues that I want to explore from your answer there. From one, I'm hearing the mixed bag of guilty and not guilty based on the charges. And just for a recap for our viewers, not guilty on murder one, so the juror is saying, hey, we didn't think this was premeditated. Guilty on murder two, so they're saying, hey, you killed her. Not guilty on burglary, and just for a quick recap, burglary is entering a location, domicile, area, whatever it is, for the purpose of committing a crime therein. We're assuming the crime would be murder here. Not guilty on that. They said yes to trespass, not guilty on possessing a weapon, and not guilty on conspiracy. Andrew, when I put those all together, in my mind, I think, okay, so you think he killed her, but you don't think he entered the home to commit the crime, and you don't think he had a weapon, and you don't think he conspired with someone else to do it. So if you think he murdered her, I keep coming back to, then how?
Sure, and I agree with you, because essentially what the jury is saying is this, that there was not a plan going into this, going over to her house and committing the crime where the murder occurred, that there was no plan. But the facts seem to suggest that they brought a hammer and it all occurred in that fashion. So why that leads me to think that the jury may be going more along the lines of just going even Steven with the other individual, with the other accomplice, is that they don't believe enough of what he's saying to believe, number one, that there was a deal that was made, number two, that they had essentially a meeting of the minds or a plan in going over there, and it essentially was that they were there and it just kind of happened. That's what they're convinced of beyond a reasonable doubt. And that's what it takes, is it has to be beyond a reasonable doubt. And a lot of juries do not like people who have cut beneficial deals for themselves. They just don't find credibility in it.
I like it, Andrew. You're shedding a lot of light on the subject. I appreciate that. I want to now jump to a clip of the closing arguments in this case, and let's see if we can dissect this as well. Let's take a look. So very interesting. I mean, Andrew, the way that this prosecutor is laying out premeditation seems to be, and I'm sorry for the pun, it seems like a 1L exam, like a first-year law student. It seems very easy, easy to follow, very straight line, and it only begs the question, why murder two and not murder one?
Sure, and I would come onto that train to say essentially that that's exactly what we have here. We have two individuals going to the house of the victim. What other reason are they going there? The defense, to the best of my knowledge in this case, never really offered a counter narrative to what places them there or what caused the crime to occur beside a plan going into it. Now, the defense doesn't have to do that. And I think what we're seeing here, to the extent that the jury was not convinced of something, is that you have to be convinced beyond a reasonable doubt. And where the evidence of certain facts, like premeditation, the intent going in, the burglary part of it, the conspiracy part of it, where that's all conditioned on the testimony of an accomplice, of another person who did this and took a dirty deal, according to the defense, they're basically washing that testimony away. And they're saying, unless there's independent corroborating evidence, we're just not going to find someone guilty of that because the burden is so high. That's the justification that I can offer. And you know what? As a defense counsel, absolutely, I would have argued that exact same thing here.
Yeah, I mean, Andrew, I think trying to understand what a jury is doing outside of questioning them directly after a case is like reading tea leaves, but I think your reading of these tea leaves is as accurate as we can probably get. I guess my frustration probably just comes from me being a defense attorney. It seems like the jury was right there on the edge, and it only took just a little maybe to push them over to a full acquittal. And so it always, for me, just comes up and be like, well, what was missing for the jury? What did they need? Or in the alternative, what did they need to find premeditation? Because I can't imagine the prosecutor giving any more than what they did to get that murder won. Could you see anything else that needed to be added?
Well, I'll talk theory for a second, and this is centered to what I do in my closing arguments traditionally. So if there's prosecutors who are going up against me, they should take note, because this is my playbook. My playbook is that unless there's corroboration for testimony, that testimony can't be believed beyond a reasonable doubt. So it's a matter of, can you get the jury to come along with that? My feeling personally is that, except in exceptional situations, you really do need independent corroboration for a person's word, because a person's word can so easily be manipulated, and you just don't know. People lie for reasons that may not seem immediately apparent. Their memories may be unreliable. There's 100 reasons for that. So where we have accomplice testimony, which is especially dangerous, I think the jury is clearly communicating, as much as perhaps they wanted to go first degree premeditation. I think that what they're probably saying is, we need corroboration for that type of testimony.
I would agree. Bold move giving your playbook away, though, Andrew, but I would agree. Let's continue with more testimony that we heard in this case. We have the cooperating witness, Curtis Wainwright Jr., who testified in court. Not sure if they found him too credible, but let's take a listen. So, Andrew, here's some of the testimony that you're saying came in, but as you kind of alluded to, or you said flat out, there's got to be some sort of corroboration other than just this person's word. So are we to believe that the jury kind of just didn't find him credible altogether and just said, hey, we're going to go with what we can see? Or do you think they may take bits and pieces? What do you think they took of this testimony?
I think that the difference between credibility and credibility beyond a reasonable doubt are different. So while the jury may be convinced that this is likely or probably what happened, and I don't want to put words in their mouth about what their feelings are in terms of the evidence, I think that what we can see is there is a difference between being convinced of something beyond a reasonable doubt and finding that it's likely true. So when he's saying essentially the lead up and the steps that go into it without something that's more independently corroborating, other than the fact that he says it, that's kind of that line in the sand, potentially. I mean, that's my feeling from the verdict here.
Yeah, and I would agree with you. And I guess the confusion that I had was, well, I think they had like surveillance of Jimmy and Curtis, like buying the hammer, buying the jumpsuits. We have the girlfriend saying, hey, we broke his phone and threw out the window, getting rid of the jumpsuits, like all this stuff that I was like, wow, like this jury really is about that burden of proof, but I guess that wasn't corroborating enough for them.
You're right. I mean, I guess the point is, what is corroborating and what's corroborating enough? That's up for that jury. I started out with my opinion here that I am surprised by the verdict, and the real potential that the verdict communicates. Essentially the jury's idea that they're not going to convict someone of a greater crime than the accomplice was convicted of, and that I'm pretty overwhelmed by that feeling here.
Yeah, I would agree. I think that is probably the biggest thing, that they say, hey, he's the accomplice, he's not the main guy, so we're not going to find him guilty of something greater. I think that's the truest thing that we've said so far, and it makes the most sense to me now. Now, we're going to continue more with this case, analyzing and others, after this break.